Out of courtesy to our LAPD, I understand there's an item here that does have police personnel. Is that accurate? I think it's item 4. Is the planner here for that case? Not yet? Okay, let's assume they're on their way. So let's go through some of the housekeeping. First, I want to welcome you to City Hall. As you can tell, the acoustics are not the best in this room. So if you have a conversation, please take it outside. We truly appreciate your cooperation. When you come to the microphone, give us your name and address. Just speak right into the microphone. That would help a great deal. You can actually tell the difference. Some of you have written eloquent letters, and it might be more than the 2 minutes allotted to you. So if you want to get to your main point in your letter, we would very much appreciate that effort. If you're in a group with several speakers, and your speakers 2, 3, and 4, and the first speaker basically said everything you wanted to say, it's okay to say, I support the previous speaker, and give us anything new or different. That will help the hearing move along. So that being said, is item number 4, the planner here yet? Yes? Okay. So let's have Roberto read that into the record.
Sure, council members. Item 4 is an appeal by Mr. Patel and Pulinar Arellano, and they're being represented by Mr. Frank Weiser. They're appealing the determination of the zoning administrator, which modified conditions of operation as it relates to the Travelers Hotel in CD 14.
Please introduce yourself.
Good afternoon, Chairman, council members. Fernando Tovar with the Department of City Planning for the record. Council members, the case before you, this is the 3rd plan approval to review compliance to conditions on the operation of the Travers Hotel. This case goes back to 1999 when the city initiated revocation proceedings on the hotel due to substantial criminal and nuisance activity emanating from the hotel, as well as other problems associated with habitability issues at the time. At the time, the hotel was the subject of some very blatant nuisance and criminal activity that was taking place on the premises and in the immediate area. At the time, there was overwhelming evidence submitted for the record based on public testimony and public agency reports, including police, fire, and an interagency slum housing task force that included building and safety and the county health department. Essentially, the hotel at the time was run amok by prostitution, narcotics, and nuisance activity. There was evidence presented that hotel residents were engaged in prostitution activity inside the hotel, where residents would actually stand on the fire escape facing the street and would expose themselves as part of soliciting customers. In addition, when some of the prostitutes were soliciting in front of the hotel and an LAPD vehicle approached, they would run into the hotel and hide. Similarly, there was narcotics activity emanating from the hotel where narcotics dealers would actually hide inside the hotel. They would run out of the lobby, sell narcotics to passing motorists, and then run back into the hotel lobby and lock the door behind them. In addition, site inspections at the time revealed that there's a side yard and an alley adjoining the site, and site inspections found that the hotel was strewn with used condoms and paraphernalia. Back in 1999, LAPD data showed that there was an extraordinarily high volume of incidents directly attributed to the hotel address. A total of 66 incidents were reported over a 2-year period. This included approximately 31 arrests or investigations for incidents that occurred on the property or directly in front of the hotel involving tenants or the hotel manager, and these arrests or investigations range from domestic violence to assault with a deadly weapon, rape, battery, failure to maintain a hotel register, or trespassers occupying vacant rooms. And those 2 last items, failure to maintain the hotel register and trespassers occupying vacant rooms, are key in terms of one of the conditions that was placed on the operation of the hotel to require a key deposit system to require that anyone who registers at the hotel has a valid ID, and basically to control access to the hotel, because room keys were being passed around and there was no control over who was actually occupying the rooms, which was leading to some of the prostitution and narcotics activity without any accountability. In addition, the fire department also had a high volume of calls, about 18 calls over the 2 years, responding to overdoses, persons who were unconscious or suffering from drug reactions, etc. For that reason, on October 12, 1999, the zoning administrator imposed 18 operating conditions that were designed to address the problems associated with the hotel. The property owner filed an appeal to the Board of Zoning Appeals, which was denied. A subsequent appeal to the City Council was also denied. Subsequently, the owner also filed a lawsuit asserting that the city's action constituted a taking, asserting violation of due process, raising claims of equal protection, as well as fair housing claims. This lawsuit was dismissed by the United States Court of Appeals. Now, condition number 1 requires the filing of the approval of plans to review the conditions, to review compliance to and the effectiveness of the conditions of approval. And as I previously noted, this is the third plan approval, and the applicant has failed to file the required plan approval for each of the previous plan approvals as well as the instant case, and the city has had to initiate the public hearing process. Moving forward to the instant case before you today, I conducted the hearing on September 13th, 2011. That hearing was attended by Mr. Patel, the hotel or the property owner, by the hotel operator, Mrs. Arellano, by legal counsel, both for the hotel operator and the hotel owner, that would be Mr. Weiser. The on-site manager, Mrs. Ayala, was also present, as well as a representative from LAPD and Mr. Smith of the United East Coalition, and there was one tenant of the hotel that attended the hearing. At the beginning of the hearing, Mr. Weiser stated that to his knowledge, with the exception of the failure to file the required plan approval, the hotel was in substantial compliance to the conditions, and he felt that the crime and nuisance activity that led to original revocation were no longer a problem. He indicated that security was not provided 24 hours a day as required by the conditions of approval, but that the security makes periodic visits to the hotel. He indicated that he did not object to maintaining the existing conditions and was not requesting modification to any conditions, but simply clarified that the Arellanos, the hotel operator, would cooperate in filing any subsequent plan approval. I then questioned the hotel operator, Mrs. Arellano, and she was unable to answer any questions regarding the day-to-day operation of the hotel. She indicated that her on-site manager, Mrs. Claudia Ayala, lives on the property, who manages the property with the assistance of her husband and is responsible for the day-to-day operation on a 24-hour basis. There's no other employees, no other shift other than Mrs. Ayala. She indicated that there was one person who provided backup to Mrs. Ayala, who was also a tenant in the building but was not actually an employee. I then questioned Mrs. Ayala, who was very forthcoming, with respect to condition number 6, which requires a 24-hour on-site state licensed security guard, and the role of the security guard is to patrol the lobby area and the sidewalk in front of the property and be responsible for removing from the property loiterers or persons reasonably assumed to be soliciting sex or drugs. If unlawful activity on the sidewalk relative to loitering, drinking alcoholic beverages, or for solicitation of sex or drugs is observed or reasonably assumed, then the guards shall verbally request such persons to leave the area and immediately notify the vice unit of such activity. If such persons are tenants of the hotel, the desk clerk shall be notified immediately to confirm their tenancy and shall evict such persons immediately from the hotel. Mrs. Ayala testified that a security guard comes to the hotel occasionally and walks around the hotel, checks the bathrooms and the hallways, but there's no 24-hour on-site security guard. She stated that there were problems on the sidewalk with narcotics activity, that during patrols, the security guard would walk toward the corner where narcotics dealers loiter, and they would disperse when they see him coming. She also stated that when the security guard finds persons inside the hotel or outside the hotel engaged in narcotics activity, that the security guard contacts the police, or in some cases has had handcuffed suspects and contacted the police.
Mr. Tovar, I think
Yes.
he's given us a really clear picture of the inconsistencies. How much more do you have to offer?
I can cut it off right here because I think that there's plenty of people here that are going to be able to give you plenty of testimony concerning
That's what I assume.
the conditions.
But for the record, you have a very articulate and a chronology of events that speaks to the position of your recommendation.
Okay. What I just wanted to if I can just briefly, I'll go, for purposes of this particular plan approval, I'll just go into the quick summary of what LAPD submitted.
Yes.
In the last year, there was about 13 calls for service, also ranging from similar activities from domestic abuse, violence, battery, things of that nature. And based on LAPD's recommendation, they requested that all of the conditions be retained. And after the hearing, after I took the matter under advisement, Mr. Weiser did ask, because there wasn't that many people present at the testimony, a lot of the evidence came in from letters that I received after the hearing. Mr. Weiser had asked that the requirement for the security guard be removed, as well as modification to some of the other conditions. And what I wanted to point out was, based on the information that I received subsequent to the hearing, I didn't think that it was appropriate to consider modifying any of the conditions, and retained all of the conditions.
And thank you. And again,
Very good.
just for the record, you have substantive information that speaks to the position that you've taken, and I appreciate the articulation of the case. Any questions for the staff on this issue, or anything he might have said?
Public comment?
We're going to go with the appeal first, the appellant, and then we'll go to the police, then we'll go to public comment.
Very good.
So thank you very much. So let's hear from the appellant, and state your case, why, the nature of your appeal.
Sure. Frank Weiser on behalf of the appellant. First of all, I want to clarify something. I think there's a misconception. I think there's a misconception here as far as the legal status of the original appeal. It was not dismissed by the Ninth Circuit Court of Appeals. I litigated the matter. In fact, Judge Rial originally dismissed it on a motion to dismiss under Federal Rule of Civil Procedure 12b-6. This was in 2003. I took it up to the Ninth Circuit and reversed Judge Rial. When it went back to him, it was stayed, pending state court proceedings, and it was the state court proceedings that we never went forward on, because we believed that we could comply with the crime would not be substantial. We believed this would just go away by itself. So in fact, there is still a federal case pending before Judge Rial. In theory, it stayed as far back as 2004. The decision by the Ninth Circuit was actually published in the federal appendix. I'm more than happy to provide that to the committee or the council if needed. Getting to the substance of this appeal.
I'm sorry, let me just ask you to pause for a second. City Attorney, the statement the gentleman just made, how is that relevant to this case?
I can't hear you, I'm sorry.
Oh, he's just asking how is it relevant to this case. I think you're just giving us background material for prior challenges that were made involved with the same property. Is that correct?
I think that the suggestion by the zoning administrator is that the previous appeal is somehow final from a legal standpoint, and with the stay by Judge Rial that never has been lifted, there is no res judicata or claim or issue preclusion for purposes of this appeal. So to the effect that one wants to argue that somehow the facts of the previous appeal are now somehow adjudicated as to the nature of the property, I don't believe that.
Okay, I understand, but maybe you can send that.
I understand. I just want to put that into the record.
Okay, thank you.
Yeah, I felt it was important for me to understand.
I understand.
Okay.
Yeah, what he's saying is the same facts were not completely litigated in a published decision, so they wouldn't be binding here. So I asked him to send me that, I guess whatever disposition of the court would explain that to me.
Okay, thank you.
Okay.
So go ahead.
But anyway, assuming arguendo that the hotel was operating as the previous appeal was contending against, in this appeal, I think it's clear there's no evidence. This hotel has rehabilitated itself. I saw no evidence at the zoning administrator hearing of any crime inside the hotel. They do have a 24-hour security guard who patrols. His name is Callaway Security Services. He's very good. He's a former police officer for the city of Compton. We've had no problems. I don't think there's any evidence of arrests inside the hotel during this whole period of time, 6 to 8 years. As far as hiring a 24-hour on-site guard, it would just be prohibitive economically. They're making $7,000 a month. There are long-term tenants here. These are poor people who are living there. And any kind of a 24-hour security guard would be at a minimum $12,000 to $15,000. So that was the first part of our request, and goes also to whether viably keep the hotel open if that condition is imposed, and then people would be displaced, which is no good for the city. The second condition was the issue of the fingerprinting and 4149. That is I believe, a serious constitutional issue. I am litigating now before the Ninth Circuit 2 companion cases that were heard, and we had maximum 1-hour argument before the circuit back in December 2009. It has not been decided, but one of them is with the City of L.A. It's litigating the constitutionality of 4149. Even if 4149 is constitutional, the question is, can you force the tenants to give fingerprinting if they don't want to give identification? And I think that's just prohibitive under the Fourth Amendment. So we would ask, we submitted new documentation to you today from all the tenants who've signed a request that the issue of condition number 4 be lifted. These are long-term tenants, and the issue of having to go and give the key when they go and come out, and then having guests have to do fingerprinting or give identification. The identification wouldn't be so bad, but the fingerprinting is just, there's no way you can get a guest or a tenant to give fingerprinting. It's impossible to comply with, and it would be violative of their Fourth Amendment rights. I don't think the city would have standing to impose that condition on the tenants. With that being said, unless the committee has any questions, I'll submit.
Any questions, my colleagues?
Thank you. So, where are you located? Your clients?
It's on Ceres Street? 5520 Ceres.
Okay. Now, have your clients filed a plan for approvals with the city as required?
They have not.
They haven't?
They have not.
Why haven't they filed?
Well, I think it just slipped through the cracks, Mr. Patel, because of the length of time over the years, and it just simply...
This has gone on for 13 years. Why? I mean, for 13 years it slipped through the cracks.
And we don't have a problem filing a plan approval. We told that to the zoning administrator, and one of the conditions is that we do file a plan approval within a year. The main conditions we are now contending against are four.
Okay, you'd stop there. To me, that's a basic tenet of operation. If the city is giving you a right to operate through our proper procedures, and there's one basic requirement to you file documentation, that is just so simple to do. And to get this, if you disagree with the fingerprinting, why did you just disregard that condition? Why don't you bring it up and talk to the proper planning officials and try to correct that, to have other ways of getting the goals of why the condition was put in place in the first place?
Well, I think it just fell through the cracks. 6 years passed or 8 years passed by. Nobody had heard from the city. I think the assumption
that fell through the cracks too.
Because
let me stop right there. What I see in this application is utter disregard for the conditions that have been put in this hotel. And that is just not acceptable. I've been sitting on this plan committee for over 6 years, and this is one of the most horrendous ones I've seen. Just falling through the cracks. Didn't know. 13 years. There's no, if I was a zoning administrator, I would have revoked this. I don't even know why we didn't revoke this. We should be revoking your right to operate on these premises. That's what we should be doing today. And I'm going to ask that of the zoning administrator, why are we revoking this? This is just completely unacceptable.
Once again, I think, number one, there is no final adjudication on the first appeal, so I don't think the council even has jurisdiction to do that. But number two, the more significant fact is this hotel is not operating any further as a nuisance hotel. There is no reason for the council to be upset about this hotel. There was no evidence pointed. The police came down at the zoning administrating hearing and said they agreed the hotel had essentially rehabilitated itself. So I see no purpose behind these conditions. But given that, we're willing to agree, if the council is willing to agree to drop 4 and 6 or come to some reasonable modification, we'll file a plan approval. That's what the zoning administrator ordered. We'll do whatever has to be done as far as the other conditions. We've kept most of the other conditions during the years. But there's no reason for you to have these conditions in place, 4 and 6, when there's no evidence that it's operating as a nuisance anymore. Are you going to displace something like 20, 30 tenants here who are low-income tenants?
Look, there's plenty.
Raise federal housing.
There are plenty of times when we've had calls to this place. So there's obviously a problem. The zoning administrator said there's a major nuisance. So for you to come up here and say there's no problem there, that's highly suspect. Number two, you're arguing for conditions to be just thrown out where we're not even doing the basic conditions we have imposed on this property, such as filing the proper documentation. Can I speak to the zoning administrator, please? My question with you is over. We are seeing this under appeal because of the conditions that you have continued from the previous years. The appellant has appealed. Why wasn't this revoked in the first place?
I think going back to what I was explaining at the very beginning, giving the history of what the conditions were like in 1999, I don't think the conditions are what they were in 1999. Certainly, does that mean they're still bad? Does it rise to the level of pursuing of revocation? You had 66 calls for service back then. You have 13 calls for service now. It's still a problem. You don't have some of the blatant activity taking place. There's still indications of prostitution activity, as you'll hear from some of the testimony. It's not as egregious as it was, where you have these prostitutes hanging out on the balconies, soliciting and exposing themselves. I'll defer to the city attorney based on the current evidence, whether or not we have adequate evidence to take the step of actually.
From my point of view, I've seen cases come before this committee where there's less egregious cases, and we revoke them. And it's been very clear. To me, just failing to follow basic conditions, to me, shows just an utter disregard. Although the areas have been helped out, improved. I mean, it started so bad. Yes, they've improved, but just because they're improved doesn't mean we should continue to reward them. We ask them to follow certain conditions, and they should follow those conditions. They came 80%, 50% to following those conditions. They didn't meet those conditions. They should be revoked. It's as simple as that. Thank you.
I know it's your district, and I appreciate.
One issue, because I want
sir, this is not. Just please.
I just want to say there's administrative.
Sir, this is not a debate. Any questions?
I was going to share some of the same information that it appears that they could be doing better, but there's no reason that they haven't complied with most of these issues. I also had an issue in the question that the gentleman suggested that number 4 be removed because of the lack of ability to fingerprint, and it doesn't say that here in number 4. In fact, the modification is that that's only if they weren't able to provide proper identification. So I don't see any reason that we wouldn't be able to have that condition in here, and that was only if, in fact, so I think it was misleading, and I just wanted the record corrected because it was stated that it would be illegal to ask for only fingerprint identification under the Fourth Amendment, and that's not what this condition says. It only says here specifically that if they weren't able to provide proper identification, then they would be fingerprinted. So I don't have any questions.
Okay. So on behalf of the appellants, we also have, I believe it's Vallabhai Patel, Adela Ariano, and Alvaro Ariano. Did you want to speak? Because this is the time for the appellants. So if you would like to speak, come on up, and then we'll go and continue for public comment. Good afternoon.
Good evening. My name is Adela Fernandez Arellano. So, can I speak Spanish? Somebody, okay.
Yes, I know two of us speak Spanish. We can't interpret for you, though. Roberto, will you please? Go ahead.
¿Puedo hablar, señora?
No, but we can't interpret.
No se escucha bien.
Sí, puede testificar al comité. Yo le voy a traducir. Yo le puedo traducir.
Ah, ok. ¿Cuál es la pregunta?
No, usted hable, le habla al comité y yo le puedo traducir al comité.
Ok, a lo que entendí que dicen que está haciendo mucha prostitución, eso no es verdad.
Okay,
yo continuamente vengo ahí y yo no estoy viendo eso.
Okay, she says that she doesn't think there's prostitution going on there, that she doesn't see any. taking place?
Segundo punto es que si hay activación de drogas es en la esquina, eso no lo vamos a evitar nosotros.
And if there is drug activity taking place, it's in the corner, and she cannot prevent that from happening.
Tenemos un guardia que él viene en las noches porque es demasiado caro. El lugar da $7,000-8,000 y el guardia por hora cobra $20 la hora. No vamos a poder.
Okay, un momentito. They have a security guard, and it is very expensive, and he comes out at night.
Tenemos una persona, no es security, pero tenemos una persona que está siempre, todo el día.
He's not a security guard, but there is somebody there that is there for security purposes.
La manejadora también se encuentra ahí. Inafortunadamente no pudo venir ahora porque está enferma.
Okay, and the manager is always present there. Unfortunately, she could not attend the committee meeting today.
Okay, en el día está una persona todo el día y la manejadora también. En la noche viene el guardia.
Okay, there's somebody there in the morning, the manager's there in the morning, and in the evenings there's a security person there.
Es todo lo que se puede hacer porque ese lugar no da mucho dinero como para que nosotros tengamos un guardia de lujo 24 horas.
And she says that's all that can be done because the proceeds from the hotel are not such that they can have a 24-hour security guard there.
Tenemos gente de más de 30 días, so no es mucho dinero el que se hace.
And they have individuals there for more than 30 days, but there's not a lot of money that is being made.
Eso es todo lo que puedo decir.
That's all that I can say.
Okay, good. Muchas gracias. So next we'll ask the LAPD to come on up. Police Department, please give us your name. Good afternoon, sir.
Good afternoon, council members. I'm Officer Stephen Nichols. I'm from Central Area, LAPD. Just a bit of introduction. I'm a senior lead officer. I was formerly assigned to the area in question, and now I've since been transferred. But in the 2 years that I was in the area, specifically 553 Ceres Avenue, it was my experience that the hotel generated calls for service that to us represented more than just police enforcement. They also represented quality of life issues. The concerns that I have, and I'll keep it simple and to the point, are not only the Part 1 crimes that have been generated within the last month, those are the felony or the very serious crimes, and the 66 calls for service that have been alluded to, but also the proximity of this problem hotel to a daycare center, which is literally down the street and around the corner. My belief is that the continued activity that is generated from this hotel, from whatever point of reference you want to start with to the current, to the present, not only impacts the crime in the area in a negative way and the quality of life, but it also, I believe, is detrimental, in a matter of speaking, to the daycare center or those parents who are forced to park in front of this hotel and wait for their children to be let out of school. I'm here on behalf of the senior lead officer for the area, Jack Richter, who couldn't be here today, but it was his concern, and he asked me to convey it to the city council, that the calls for service that continue here, again, the 3 Part 1 crimes specifically that relate to this, are ongoing, that the problem has not been addressed, and that this is just another example of enforcement that we would like to take to end the problem location, but heretofore has not been able to be undertaken.
Would you, given the instructions and recommendations from the zoning administrator, would you say that we could do, how can I put this? Can we do more enforcement through our conditions that would alleviate some of the pressures you have and the pressures the community feels? Are you familiar with the conditions that are being imposed?
Yes, sir, I have read them.
And do you think that that is enough, given your experience?
If I may, sir, the conditions and what has been imposed or has attempted to be imposed with obviously little to no success are fine as far as they go. But if they cannot be imposed and there is a sustained history of them not having been adhered to, followed, or otherwise followed up on, I believe that the next step, if these will not be adhered to or enforced, should be revocation.
Okay. That's important. Councilman?
Thank you, Mr. Chair, and thank you for being here, Officer. One of the conditions was that they were to meet with the LAPD on a quarterly basis. Have they been meeting with you, with the LAPD, on a quarterly basis?
To the best of my knowledge, they have not. Again, I'm here on behalf of the senior lead officer assigned to the area, but he has not told me that he has had any meetings, regular or otherwise, with the hotel.
Okay. I've been told that they have not met that condition either, and I just want to verify that with you. And in terms of resources for our officers in the area, the number of calls to this property have declined, albeit started pretty high.
Yes, sir.
But has the number of resources in the area for our officers increased or decreased, or do we know if the number of calls, they're just response times or actual calls?
The actual calls are not only to the hotel, but the area immediately adjacent to the location. 66, I believe, is the number. That's since February. But to the hotel, the specific address at 553 South Ceres Avenue, there have been 3, and those were Part 1 crimes, which means those are felony-related or obviously the more serious crimes.
Yes. Okay. Thank you.
Okay. Any other questions for our officers? Well, thank you, sir. Thank you for your due diligence and for what you do for the city.
Thank you, sir.
Thank you so much. Okay. Let's see, no other officers out there. Let's proceed with public comment, and I'd like to invite Estela Lopez. Good afternoon.
Good afternoon. Hi, council members. Yes, I'm Estela Lopez, the Executive Director of the Central City East Association, and I'm here not only to ask you to deny the appeal, but if it is within your jurisdiction, that you revoke this hotel's license. This hotel, in a cavalier manner, has, since 1999, ignored the city's conditions, appealed the conditions, and filed suit against the city over these conditions. The people who live and work in Skid Row around this hotel, as well as the city's police resources, have been the ones to pay dearly for this hotel being given chance after chance after chance. Our BID security has observed criminal activity and antisocial behavior in and around this hotel for years. As recently as this weekend, council members, our security monitored this hotel from 7 a.m. until midnight, both Saturday and Sunday. Here are the security logs. There was no security observed at the location at all during those 48 hours, knowing they were coming here to a hearing. In addition, on Sunday, night before last, at 9:45 p.m., our security supervisor observed 2 Hispanic male prostitutes, and he knows them well, exit the hotel and walk southbound on Ceres. One of them called out to our supervisor, who was driving a marked CCEA vehicle. The prostitute took off his shorts, revealed his underwear, and asked our supervisor if he wanted a date. This is the history of this hotel. Council members, this is not a case that deserves yet another chance. It's the community that deserves another chance to be free from this type of criminal behavior. Skid Row is home to dozens of hotels that are properly run. What we're asking the travelers to do is not impossible. They simply have no intention of abiding by the law, and they haven't for more than a decade. Please exert your leadership, protect the families and workers in Skid Row, close the travelers. Thank you very much.
Thank you. Thank you very much. Elizabeth Galeon, and then Kevin M. Key. Elizabeth, are you here? Representing Para los Niños? Okay, come on up. I have one card, so someone didn't fill out a card. Maybe we can do that before you leave. Thank you.
Okay, my name's Martine Singer, and I'm the president and CEO of Para los Niños. I'd like to thank the Plum Committee for allowing us to speak on the issue of revoking land use privileges at the Travelers Hotel. For more than 30 years, we've operated the Tina and Rick Caruso Child Development Center at 845 East 6th Street. Adjacent to the Travelers Hotel, our properties share a common alleyway. As the only provider of child services on Skid Row, Para los Niños faces many challenges. One of the most intractable and long-standing, unfortunately, has been the Travelers Hotel. I'm here today with another staff member, Elizabeth Gallion, from Para los Niños, who will graphically describe for you the conditions that she, her staff, and our children and parents encounter on a daily basis. But first, I'd like to tell you about our Skid Row programs and the vulnerable young children and families we serve. Each day, we care for 125 children ages 6 weeks to 4 years old at the Caruso Child Development Center. Next door, at 838 East 6th Street, is our Youth Workforce Services program that prepares approximately 175 youth ages 17 to 21 for gainful employment. Across the street, also on 6th Street, is our Clinical Services program, which counsels about 16 families each day. So each day, between 125 and 300 children, parents, and young people arrive in this one block area to seek our services. Unfortunately, they're forced to see human degradation and illegal behavior courtesy of the Travelers Hotel. This means that very young children witness sexual acts performed in doorways and on the sidewalks. Meanwhile, their parents are solicited to buy sex and drugs and then threatened with violence when they decline. And by the way, we're a nonprofit organization with very limited funding, and we pay for a private security company every day for this very reason. Mr. Patel is well known to the City Housing Authority as the operator of other properties that have been cited for code violations. And in 2003, he was sued by the city attorney for substandard conditions at the Stewart Hotel, where prostitution and narcotics trafficking were also reported.
Ms. Singh, I need you to conclude.
Okay. We are in a safe school zone. It's decidedly not safe when our families need escorts to walk to the doors of our buildings, nor is it safe when their vehicles are vandalized and their children traumatized. Our children face enough trauma and hardship every day without having to witness crime and squalor. Thank you very much.
Thank you, Ms. Singh.
Good afternoon, Council. Thank you for hearing us. I've been at Para los Niños since 2008, daily basis as the site supervisor. So I've observed it, I've seen it. I've seen the horrified look on the parents' face as they walk in and come into my office upset, especially the males that drop off their children. It's very sad to see this. We do incident reports and things like that, but the problem is still there. It's the same as it was before, since I've been there. Parents should feel safe and secure dropping off their children. This criminal activity, we hear frequent parent complaints. They're solicited by prostitutes and drug dealers. I frequently see prostitutes yell obscenities. I've actually seen the prostitute jump on one of our other site supervisors' cars. We've had exposing behavior, and that's why Jack Richter and I, we've actually had meetings out in front trying to add additional lighting. We've done things to help the security, but yet we're not getting that from the Travers Hotel. This past Friday, we tried to just do we're going to change the youth center to mental health services. Couldn't even look out in the alleyway full of dog feces. We don't have access. These people do not care. They don't care that we're dealing with children. They leave their dogs without leashes. It's just unsafe, pit bulls and things like that. This is just an accident waiting to happen. We just got a call March 22nd of this year. Someone left a hot plate, and the fire department, additional city resources. We're providing an excellent service for children and families. This is just blatant disregard for these families. Please consider this shut down.
Yeah, thank you for taking the time. Kevin Key, that'll be the last speaker.
Chairman Reyes, council members, my name is Kevin Michael Key. I'm here wearing multiple hats. I work for United Coalition East Prevention Project, located on 6th and Gladys, and we do environmental nuisance work, prevention work. Corrective conditions complied with, have made improvements in many of the area businesses, and so to see a situation where they continually disregarded speaks to the intent of the owner. Obviously, his intent is not to do the work. As a resident, Skid Row is my home. I got clean and sober in this community. As such, I have a sort of street sense as to what's going on. I didn't know about this hotel, but I know what my spidey sense sort of told me as I drove those streets and witnessed the activities. And it needs to stop. Carlos Linos is there. We're trying to project Skid Row as the world's largest recovery community. We work on a daily basis trying to abate some of that. So if they're not going to comply, then they don't need to continue operating. We don't want to see displacement. In a letter dated April 2004, our director indicated there were other means the city could use to do that. Finally, I'm a member of a Skid Row theater group called, I'm the other LAPD, the Los Angeles Poverty Department. I would like to invite all of you, and particularly our council member, Mr. Huizar. We're having a parade in Skid Row to project the positives. We're going to march past there, but we're going to honor Tanya Tull, who was the founder of Para Los Niños. Let's get together, clean up Skid Row, and get rid of places like that, and let's build the community that we all want to see. Thank you very much.
Thank you, sir. That concludes public comment. Councilmember, any recommendations?
Yes, Mr. Chair. I am quite appalled about the record before us, and I'm a bit concerned that the only thing before us is an appeal where the appellants, the owners of the property, are appealing certain conditions. The record before us, to me, signifies the possibility of revocation, and although that's not what is before us today, what I would like to do is ask for a continuance of 2 weeks so I could research and determine whether revocation can be implemented at this property. That's my recommendation.
Okay. Now, are there any time constraints to the 2 weeks? Do we have a clock that we have to follow to act on this matter?
Mr. Chair, this item, there is a time limit, and it is noticed for council June 5th. However, the last day for council to take action is June 12th.
Okay.
So can we do 1 week continuance, and that'll be next Tuesday, correct? And I'm not sure how if the agenda is filled with that, Mr. Chair, or we could do 1 week.
I think we can accommodate that.
Okay.
My assumption then is because of the constraints to council, we cannot do the 2 weeks, but we can do the 1 week. Correct, Madam Clerk?
Yes, Mr. Chair. This can be heard in committee next week, and that would be May 29th. And then this item can be scheduled for council on June 5th.
1 week from now is the 22nd. Did you say the 22nd?
29th.
Oh, today's. I'm sorry. I'm looking at the wrong date here. You're right. I'm sorry. Okay.
Mr. City Attorney, just as a word of caution, and I appreciate Councilman Englander's observation, if the action before us is to set conditions, but if we take action to revoke to see if it's even possible, does that trigger another public hearing, another public comment, and does it engage a whole other level of process, or can we move in?
Well, no, yeah, we have to take first things first. We have to examine whether we could even proceed with revocation under this process here, and I think that's what the councilman is asking to look into. Is that correct? Mm-hmm. And then, if that is possible, I would assume that, yes, you'd have to have a public hearing on that, because right now we're just reviewing the conditions.
Okay.
Yes. I want that one. I prefer this 1 week so that we could research rather than, I motion right now that we do a revocation and then set up unexpected time limits and hearings. So I'd rather just have this 1 week, look at this more in depth, and then come back and figure out where we're at.
Okay, so then we'll just take it one step at a time then.
Yeah.
So we'll continue this 1 week, and we'll stay within the limitations of the time constraints. and then we'll follow you, Councilman, as to the best approach you want to take in addressing this concern. Okay, so continue 1 week. All right. So let's get back to item 1, Roberto.
Sure, council members, item 1 is a city attorney report. It has to do with the action of the Superior Court relative to a writ of mandate in a case entitled West Chandler Boulevard Neighborhood Association versus City of LA.
Okay, let's have the staff come on up. So, City Attorney, as the staff is coming up to the microphone, this is not a closed session item, correct, Mr. City Attorney?
Oh.
Item number 1 is not a closed session, right?
Oh,
or is it?
A second.
It is. Okay, let's do this then. If it says closed,
Yeah, it is closed session.
it's closed session. So let's do that one last.
Okay.
So we can get through the agenda and not keep everybody waiting. So next item, Roberto.
The next item, council members, is a Cultural Heritage Commission report to designate the Firestone Tire Building as a historic cultural monument.
That, I see no cards and it's recommended for consent. Are we okay with that? Can we move this item? Thank you.
Can I ask one question?
On item 2.
Just item 2, if we tried to reach the owner and appeared that we've exhausted that, I just wanted to make sure that if we go on consent, that was actually stated for the record.
Okay. So that's been, it's unanimous from the committee to move that on consent with the observations. And is that a condition that you just stated?
No. It was
just an observation.
There was an observation that there was many attempts by the city to do that.
Okay, good. All right. So that moves item number 2. Item 3.
Item 3, council members, is an appeal by Michael Gangbard, representing Raya's Paradise. He's appealing the determination of the zoning administrator, which denied a reasonable accommodation permit. The project is located in CD5.
Okay, let the staff come on up. Okay. Gotcha. Yes. Thank you. Good afternoon, sir.
Good afternoon, Chairman Reyes, members of the committee. My name is Charlie Roush, Associate Zoning Administrator. At the time this case was written, I was a senior city planner, therefore it was signed off by the Chief Zoning Administrator in her capacity. The project before you is a demolition of an existing duplex on Sierra Vista Avenue in the Hollywood District, and its replacement by a 2-story, 4,636 square foot, 11-bed residence for assisted living, dementia care housing. The structure will have 5 single, 3 and 3 double bedrooms, a living room for residents, and a kitchen facility on the first floor, and 2 offices and a conference room on the second floor. Parking is available for 4 cars on the site. The project was originally filed as a variance, which was denied last October by Associate Zoning Administrator, who found that since the applicant has a right by state law to place 6 beds in each unit of the existing duplex for a total of 12 on the site, they have a right by state law to do that. Therefore, there was no hardship that impacted the property for the intended use. There is no, they also ruled that there is no disparity in privileges. The applicant can still use the site for a residential care facility. The hardship was self-inflicted because the applicant wanted a unified building while the zone allowed 2 6-bed facilities. If they destroyed the building and came up with a one unit, they would be limited to 6. He also ruled that we would be granting a special privilege as the requested use. Elder care is first permitted in the R4 zone, and it would set a precedent for similar facilities in the area that at that time had 9 assisted living facilities in either single-family duplexes or small apartment buildings. There was no appeal on the case. It came back to us on December 14th as a reasonable accommodation case, which is for housing for individuals with a disability. This request was also denied by the Chief Zoning Administrator on March 6, 2012. The appeal of that decision is before you. On reasonable accommodation cases, the staff has 4 findings which to make. We agreed on 2, we disagreed on 2. Finding number 1 is the housing, which is a subject request for reasonable accommodation, will be used by an individual with a disability protected under the Acts. We agreed on that particular finding. Moving on, the second finding is the requested accommodation is necessary to make housing available to an individual with a disability protected under the Fair Housing Acts. We disagreed on that particular finding and denied the case because of it. We found the facility is in an area that is currently served by the applicant himself with 3 6-bed facilities within the area, which is basically the 2-block strip of land between Melrose Avenue Boulevard and West Hollywood city limits. There were facilities with at least 30 beds in the vicinity owned by the applicant himself. He also has 2 in the city of West Hollywood. And that there was only counting the applicant's facilities, and that there were more in the area, especially the 2-block wide strip previously mentioned. Secondly, we stated that state law permits the applicant by right to convert a residential unit into a 6-bed facility with no approval from the local municipality, as long as they remain separate licensed facilities. Thus, the applicant had a right to 2 6-bed facilities, and there was no need for a reasonable accommodation on the site other than to tear down the building and build something that was entirely new. And we believe the accommodation in this case was not directed toward housing individuals with a disability, which he had a right to do under state law, that as an attempt to circumvent the zoning code in regards to where elder care facilities could be built. The mere repackaging of the denial is what we decided that this case was, and so we denied it on those grounds. Finding number 3 is the requested accommodation could not impose an undue financial or administrative burden on the city. We agreed with him on that. The applicant, anyway, we agreed on that one. And the 4th, which we also disagreed with, is the requested accommodation would require a fundamental alteration in the nature of the city's land use and zoning program. We found that this would require a fundamental alteration because it would be an intrusion of a use first permitted in the R4 zone in our most restrictive multifamily residential zone, which is the R2 zone. It is designed from the ground up as an institutional use in the interior of an R2 neighborhood. Many times we will have requests for these kinds of uses. They're on the corners of major boulevards, secondary highways, and the like. This particular site is 3 lots in from a corner in an area that is solidly residential, and they're except for the Collector Street on Willoughby Avenue, everything is a local street in this area. Lastly, I would like to respond to the appeal of the applicant in one particular area where he notes that we are discriminating for we would not allow individuals with a disability to make housing choices of their own if such choices existed elsewhere in the community by turning down this particular case. In response to a discrimination complaint filed by the applicant against the city for discrimination against those with a disability, it was found in our background checks of this area that there are currently 18 facilities operating within the 90046 zip code in which this particular site is located, in zones ranging from the R1 to the R4 zone, with a total of 569 beds available. Now, that doesn't mean that these beds aren't currently occupied, but they are in operation. Within the 2-block strip between Melrose and West Hollywood, Sweetser Avenue, and La Brea Avenue, there are a total of 9 such facilities located in single-family homes, duplexes, and small apartment buildings, and those have a total of 246 beds, and that is the immediate neighborhood of this particular site.
Thank you, Mr. Rausch. Any questions from the staff? Seeing none. Let's go with the appellants. My understanding is Michael Gumbard, I believe, wrote a card. He is the name.
He's being represented
by
Robert Chernin.
So who else is under the appellant? Just
the
himself?
appellant is my client, but I'm representing my client here today.
No, I understand that, but then anyone else that's identified as part of the appellant, or just him?
Just him.
Okay, then go ahead, Mr. Chernin.
First of all, I'd like to state that this is unlike any other case that this committee has ever heard. This is not, usually you're here listening to issues of land use. Today we're listening to issues of the rights of disabled to reasonable accommodation for their special housing needs. There's a shortage of housing for Alzheimer's patients all over the country. Here in Los Angeles, we have a major shortage. There's been mention made that my client has other facilities available that could be used for people who have the need. My client, in the original application for appeal, I stated he had a 95% occupancy rate. In fact, he has 0 vacancy rate now. He has a waiting list. And it's not only my client, but there are several other facilities in the area that also have waiting lists. There is very few of these type of facilities, and I want to make sure you have the clear picture of what we're speaking of here. I had a reporter yesterday come and ask us when we're going to develop another facility. They drove by it and thought it was just a home. In fact, it's been a facility for assisted living residents for 5 years. These facilities blend into the community. They're not institutions. They're not hospitals. The whole idea of this is to give people who are stricken with the terrible disease of Alzheimer's a home-like setting where they are familiar with the environment rather than a hospital setting. My client goes out of his way to make sure that his properties blend into the community. He's been doing this for over 20 years. He's received awards from the city of West Hollywood because he does treat his patients like they're his own family. I have here that I've submitted, and you have in your package, price ranges from existing duplexes that he in fact has existing now as opposed to 11 residential facility that he has in West Hollywood, and it's very clear that there are a lot of disabled people who are being denied the right to this type of housing because of the price difference. The city is telling my client that you should be forced to have 2 units, 6 each, in a duplex rather than a single unit, forcing people who can't afford it to no longer be able to have the opportunity to have this kind of housing. I've also submitted to you the indication that he has 0 occupancy availability here. I think the problem here is educating the community. He has offered to have the people in the community come and reach out to them, and once they do, the LA Times did the story, one of them who opposed him realized that she was wrong and in fact asked him about having one of her relatives move in, and he had to tell her, unfortunately, we don't have any available room right now for any more. That is the whole purpose why we're trying to get the city to allow us to build more. This is not a means of him having other facilities in the area take patients that have asked him, because they also have waiting lists. There is the Jewish Home for the Aged that have a waiting list of 800 people. This is very common with some of these better run places. The only places that do have availability are the ones that I wouldn't want my family members to go to. I've had them as former clients. They don't function, they don't take care of the patients, they're warehoused and they're neglected. We have to start paying attention to the rights of people who have been good citizens in our city, who have contributed for years and have been stricken with this terrible disease, rather than the fears of some of the statements that it's going to lower property values and we don't want this in our community. We should be opening our arms here in Los Angeles like other cities have done to my client and asking, tell us what you need for us to help you so that we can assure that people who are stricken by this terrible disease have the assistance of the city, rather than telling them that you should go to some other city, we don't want you here. The law is very clear here, gentlemen. We have filed, and you have in your package, we have filed with the state of California and the federal government complaints that the failure of the Department of Planning to recognize the rights under federal and state laws and give my client his rights under the law is a violation and it's discrimination. And unfortunately, if it doesn't end here today, I've been told by the state that they're going to file criminal charges, and I want to make it very clear that there are a lot of good people who benefit from the housing funds that come from the federal government and the state. They're going to be the victims also here, because the state can suspend those funds. And we don't want to see that happen, but we want to see you work with us on this. And I think, again, it comes down to education. The state has asked Mr. LeGrand and the city attorney to come and sit down and work this out. Mr. LeGrand offered me next week a meeting. I would hope that you would put this off until such time that we can sit down and really discuss what the responsibilities are of the city under federal and state law, so that the rights of Alzheimer's patients are not denied here today.
Thank you, Mr.
Thank
Chairman.
you.
We do have other speakers.
I'd also like to recognize a lot of people who aren't going to be speaking. Would you please stand up, who came here today? And please. and really care about this issue. A lot of them are directly involved with family members who are stricken by this disease, and they want the city to know that they need your help. They want to be able to provide proper places for their relatives. Thank you.
So the cards they submitted doesn't mean they want to speak, or they do want to speak?
No, the ones that submitted cards do want to speak.
Okay.
The ones that did not submit, I just wanted to recognize them. Thank you.
Thank you, Mr. Chairman. Denise Weinstock, and then followed by Veronica Chernin, and then Alex Foxman. If you'd like to come on up behind the microphone, now we can keep the committee moving. Go ahead.
Good afternoon,
Good
Councilman
afternoon.
Reyes and Councilman Huizar. Councilman, as you know, I'm a resident of Mount Washington, and so I'm one of your fellow district members. I'm a professional fiduciary. I live in Mount Washington, and my office is in Pasadena, and that's the address on the card. I'm a professional licensed fiduciary in the state of California, and I handle the personal, medical, and financial affairs of seniors. I have clients who live in homes, who live in nursing homes, who live in assisted living homes, board and cares, locked psychiatric units, etc. And I attended the outreach meeting that Mr. Gambert held at the facility. It just so happened I had a client who was living at this board and care facility, at the facility where he held the outreach meeting. I was outraged by the ignorance and the ageism that I heard expressed in that meeting. Mr. Gambert sent DVDs out to all the neighbors, and there was a very small showing. There was only 3-4 people besides myself that showed up. He had a big spread of food. And the comments that I heard are these. One lady said that she opposed the project because she didn't want to be walking down the street with her child in a stroller and have that child be attacked by a person who has Alzheimer's disease. Really. I can tell you that's the most outrageous thing that I've ever heard. Any client that is in this facility that I have, if they do take a walk in the neighborhood, is accompanied by a caregiver, and just because you have dementia doesn't mean that you're going to attack a small child. It may be the other way around, that a small child may knock over a senior citizen who's got a cane or a walker. Another person that was there offered a quid pro quo, that if the owner of this facility were to repair his sidewalk, which was across the street, then he might give them their support. Another one said that there's crime in the area that's increased, and that they would, if they paid for security in the neighborhood, that they would offer his support.
Thank you, Ms. Weinstock. I just need you to finish. We got the 2 minutes, so we have the 2-minute clock. So I need you to conclude.
All right. Well, I will just say that from this meeting, there were people that wanted seniors to pay for security for them, and they made false accusations about the nature of seniors and their disabilities. And, I'm sorry that I guess I spoke too much about where I'm from, but the comments that I heard, I'm going to write a letter, and I'm not going to give up, because the ageism that was expressed by the neighbors was outrageous.
Thank you very much. Veronica Chernin. Good afternoon, ma'am.
Hi, hello, my name is Veronica Chernin. I'm just here personally to discuss what has happened in my own personal life. Although I work in the industry as an accountant and do the bookkeeping for the residential elderly that live at Reyes Paradise, I'm just here to share something that has happened in my life. Personally, I'm young. I shouldn't even be considered dealing with elderly people, but I know that they need a place to live, and I have had a grandmother who has had Alzheimer's, and I wish that there was a place like Reyes that she could have had somewhere familiar and helpful to live, rather than a skilled nursing facility that doesn't offer the same care and support. I just wish that people would be more open to these types of ideas, and to be more understanding that people are afraid and don't know where they are and are not going to hurt anyone, are just going to live their life calmly and peacefully, and they should have the decency of being able to, if they have to go, they should go at home. I just want to thank you.
Thank you, ma'am. Alex Foxman, and then Israel Gambert.
Chairperson, Chair members. My name is Dr. Alex Foxman. I'm the founder and president of Mobile Physician Associates. We're one of the largest mobile group medical practices in Los Angeles, and we currently service approximately 600 patient visits per month here in Los Angeles. I'm here in support of Reyes Paradise. They're one of the facilities that we visit, And just a couple of very basic facts that you might all know, not very much medical facts. Human beings do age. Human beings age, they become older, and some of these human beings become sick. And when they become sick, they need special care. Sometimes they become sick where they need people to take care of them at home, and if they're not able to be taken care of at home, they end up in hospitals and nursing homes. Ambulances become very common in an area where people aren't taken care of. If you have people and patients who are taken care of very well, there are no ambulances. When you have people and patients that have good organization skills, they're able to take care of people in a very well-structured community setting. And that's what we're talking about here, is taking care of people. And these people are your parents, your grandparents, your uncles, your aunts, your sisters, your brothers, who might have medical issues that need to be taken care of. And the solution is not to kind of sweep this under the floor and have it taken care of somewhere else or have it taken care of in a nursing home. These are real-life issues that are only going to get worse. Every day, thousands of people become older, they become sicker, and they require these types of services. And operators like Raya's Paradise, who've been around for over 20 years, are able to assimilate into a community, be able to provide these services in a way that is good for everyone. Raya's Paradise operates maybe, 10, 12 of these facilities, and personally, I see the value of these facilities, how they've helped the community, how they reduced the footprint in the community as well. There's less staffing because this is a consolidation of services. And if you try to separate this into small little 6-bed facilities, you're actually increasing the footprint and decreasing the surrounding community environment. Thank you.
Thank you, Doctor. Israel Gumbard? Israel, you here? John McGee? And then Greg Kuros, I believe. Good day, sir.
Hi, my name is Israel Gambard. I'm actually one of the designers who builds and designs these homes, and I think it's very important that you and the community understands that by law, Raya's Paradise is allowed to build side-by-side units with 6 residents in each unit. With that said, if we need to build side-by-side, we'd have to go up, so it would be a much bigger facility. And it's going to stand out a lot more. What we're offering is actually doing an 11-bed with 1 hallway versus 1 kitchen versus 2 kitchens, and 11 residents instead of 12 residents. Thank you.
Thank you, sir. John McGee? Then Greg Kuros, I believe? Good afternoon, ma'am.
Good afternoon. My name is Joan McGee, and I work for Jeffrey Siegel, who's a conservator. I'm a case manager, and I've been a case manager for 15 years. I've been going to Raya's for about 6 years, and I have about a clientele of about 50. And Raya's Paradise, hands down, is the best facility. I never have to worry about my clients. Clean, neat. I mean, you should see this place. It's great. I go to several other facilities in the area, and they don't even compare. I had a friend of mine who's a real estate agent who was selling a property across the street for about 2 months, and he had no idea that the place directly across the street was Raya's, and I went over there because I saw his name on the marquee. My heart is beating really fast. But anyway, he had no idea. I mean, they really blend into the community. They're just a wonderful family. I mean, they really do take in the clients, and they make them their family. And I think all of you would, if you could just go and check it out.
Thank you.
Okay, thank you.
Thank you, ma'am. Greg, I think you're misspelling your name or pronouncing it, I should say.
It's Overos, Greg Overos.
Overos. I thought it was a Q.
I'm sorry.
All right.
I wrote it, so I have to take responsibility. My name is Greg Overos. I, too, am a professional conservator. I'm a social worker and a gerontologist. I've been working with older adults since 1985. And what I want to speak to is the need for facilities like this. Most older adults, as they age and as they are in their homes, they want to stay in their homes for as long as possible. And if they have the funds to do that, they can, but often being in their homes is not in their best interest because they become isolated in their homes. In a board and care facility, they are with other residents, there's other activities, there's stimulation, and as far as they're having dementia and Alzheimer's, it really helps facilitate their care, and they benefit from being in a facility. And the small board and care facility is as close to being a home-like setting as you can have without being in their home. We need more facilities like this for our aging population. Thank you.
Thank you, sir. Dr. Elizabeth Farr?
Hi there.
Hi.
I became a gerontologist in 1983 and a clinical psychologist in 1999. This day truly saddens me that I'm here trying to tell everybody how important it is to take care of our elderly. I was trying to think back on when I first came in contact with Rise Paradise, and I remembered now that it was in trying to help a family trying to find an appropriate setting for one of their loved ones, and how difficult it is to try to find such a place. And ditto to everything else everybody else has been saying about how wonderful the place is, how clean they are, and how important it is. But also something that I don't think was mentioned, and that is that when you have a side-by-side unit, you also have, when you have one community area, one kitchen, one living space, you also have the opportunity for a larger group of people to come together. And the ideal setting really for people to come together is 8 to 10 people. And that provides an opportunity around dinner to sit together and to share stories and to talk with each other. And I think that's really what's missing. And I think that gives a human component back to being really in a family again. And that's what Raya's Paradise really enables people to have, that sense of family. And I think that's what's special and unique about them. And I really hope that you today are able to reconsider the decision and really remember your own families and think about how you would like them to be taken care of. Thank you.
Thank you, ma'am. Next speaker is David Jones, and then Valerie Valdez-Jones, then Celine Mayers. To come on up. Good afternoon.
Good afternoon, council members. Thanks for taking the time to see us. Listening to all this testimony makes us sound like we're all evil neighbors. And let me just start by saying that the neighborhood isn't opposed to Raya's Paradise being in the neighborhood. They're just opposed to them making a 4,500 square foot building where all the buildings are 2,000 square feet. It's a neighborhood. It's a working class neighborhood. And this is going to be a monolith. And we just don't want that. We're not opposed to old people. A lot of our grandparents had Alzheimer's before they died. My wife's grandmother has dementia. We're empathetic. We're not bad people, but we live in a neighborhood. We don't live in a commercial zone. That's all this is about. So thank you for taking the time to hear us. I'm David Jones. I'm a resident of the 800 block of Sierra Bonita Avenue. I'm an Evangelino, a veteran, a taxpayer, and I'm also a homeowner. I recently purchased my home last August. At that time, I was unaware of the plans to build a nursing facility. Had I known, I would have looked elsewhere to buy. If the facility at Reyes is proposing is built, I'm afraid other potential buyers will feel the same. Having this large structure on our street would change the character of the neighborhood. A 4,600 square foot, two-story building in the middle of the street whose charming 90-year-old houses are about 2,000 square feet and down. It's not what the city planners envisioned. It's not what they intended. The variance would invite new developers in our small, tiny neighborhood seeking similar variances, further decreasing the value of our homes in an already troubled housing market. This variance will save money for the owners of Raya Paradise. That's it. It's about money. It's going to cost us, the homeowners here today, a lot. Please help us save the neighborhood and deny this variance. Thank you very much.
Valerie Jones, please.
Good afternoon. My name is Valerie Valdez-Jones, and I am a homeowner on the 800 block of Sierra Bonita. And I am here to express my opposition to the appeal for the variance and ask you to deny this request. The owners of Raya's Paradise already own 3 properties on our block, and they have been purchasing additional local properties at an alarming rate. I believe if granted, this variance could open the doors for Reyes Paradise to build more commercial care facilities in our neighborhood, and it would also encourage other developers to do the same. This is not about the elderly or their need for care. This is about making money. Reyes is a private, for-profit facility. They do not even accept Medicaid or private insurance, only cash or check. I don't have a problem with small care facilities at all, as provided under state law, but this request for a special favor, for a special interest, is the increased profits that Reyes hopes to make by skirting the long-established rules prohibiting commercial activity in our area will come at the expense of all the residents in the neighborhood. My husband and I recently moved to this neighborhood to raise a family. If we had known of these plans, we would not have purchased here. We've spoken to most of the neighbors on our street and many in the surrounding area, and not one of them supports this variance. We have submitted a petition, as you guys all probably, I hope you have, to the clerk of over 50 signatures of residents in the neighborhood asking you to please deny this variance. Thank you.
Thank you. Mr. Mayors and Peter Nichols.
Hello, my name is Celia Lattis, Your Honor. I am a resident of the neighborhood for the last 15 years. I am a registered nurse. I have nothing but compassion for seniors. I understand, I work with them. This isn't anything about the seniors or about the facility to take care of them, but this is a nice, quaint, charming neighborhood. This is not a commercial neighborhood for this facility. My neighborhood is already oversaturated with these type of facilities. And I do want to put in perspective about the waiting list to take care of the seniors. Yes, there is a long waiting list, but it's for Medicare patients. It's not for private pay patients. This is a very greedy for-profit operation. That's fine. Why doesn't this person build it in his backyard? Why does he have to come to my community that's already saturated? I have nothing, as I said, but compassion for seniors. I take care of them. But we have too many. Yes, this facility that he has on Gardner blends into the community, but the ambulance sounds do not blend into the community. Our streets are narrow. They're blocked by ambulance. Parking is limited, and it already is a challenge. I strongly encourage you to oppose this demand, and also the idle threat that their attorney said that they will file another suit is just so concerning to me. It's like a little kid. If you don't get my way, I'm going to just keep coming back at you. You know, there's a lot of vacant commercial lots where you can put this facility, put some trees, put your flowers, but please, I encourage you to strongly oppose this project. Thank you.
Thank you very much. Peter Nichols and John Fitzpatrick.
Hello, I'm Peter Nichols. I'm a resident of the neighborhood. Please don't be bullied, okay? I'm here today speaking against the appeal of Reyes Paradise expansion efforts into our residential neighborhood. I've lived in the neighborhood for 12 years. I also run our Neighborhood Watch program. We have a website you could check out, melroseaction.com. As someone else spoke, our area is already super serving the nursing care industry, and we are oversaturated. And definitely this only adds to this issue. It is disheartening to fathom that, in fact, we are debating whether a residential zone should be subject to yet another expansion of a for-profit operation, unmitigated by even a CUP. No mitigation whatever. I mean, this is assuming that this business has no impact on our quality of life. When we already have no parking, we suffer from emergency services that come to their facilities, because these facilities basically operate 24 hours a day. They're businesses, okay? They're for-profit businesses. I echo what my other neighbors have said. I didn't invest in my property nor did people who have lived in my neighborhood for 50 years or more and put their hard efforts at paying down their mortgage to see their property values get hindered and dinged because a nursing home decides to open next door to them or up the street. You know, when is the city going to stand up for us and stop this encroachment of businesses into our neighborhoods? As you all know, there's plenty of lease space available in commercial zones. Let's put them where they belong, in a commercial district. There's plenty of nice areas there. I'm opposed to this, and please don't be bullied.
Thank you. John Fitzpatrick and Christopher Combs. John Fitzpatrick and Christopher Combs.
Hi, my name is Joan Fitzpatrick. I am a realtor, and I also reside 2 blocks away from Gardner, where this nursing facility is, and 2 blocks away from the new one on Sierra Bonita. I sold the home to these 2 people over here. I had no idea, Valerie and David, I had no idea that there was going to be a nursing home there. Do you realize how this will impact the income of everyone and the property values of every person in this area? I have a duplex on Stanley Avenue and a duplex next to me. If they bought that duplex next to me, do you realize what that would do to my life, to my income, to my future, to my retirement? I'd be dead. If I could afford to live in one of those places, I understand they're $6,000 a month. They have 6 facilities. Do you realize that's almost $500,000 a month that they're making on us? I'm paying $10,000 a year in taxes, as is everybody in this room that lives in our area. We cannot have this. This is insane to have all this commercial goings on in our little neighborhood. This is our future. It's our income. How can we possibly retire? This impacts all of us. Do you realize the money that they are making? Look at all these attractive people. Believe me, there's nobody on Medicare in any of those facilities. Put them somewhere else, but not in our neighborhood.
Thank you.
They don't even have a fence fencing those people in. They have a row of trees on one side of that house. They have no fence to protect those people. A dog, a homeless person can get in there. And I walked by there and I've said to somebody, please, why don't you get a fence? Anybody can get into that facility. I'm sorry to be so emotional, but I cannot help it. I've lived there for over 10 years.
Okay, ma'am. I understand.
How would you like it if they opened a facility right smack next door to you?
Thank you. Thank you very much. Thank you. Christopher Combs.
Okay. Christopher Combs on behalf of Councilman Paul Koretz, Council District 5. The councilman is opposed to this appeal in support of the decision that staff made. I know there's been a lot of emotion in this room and there's been a lot of testimony. All I would add is I think this is actually much more narrow than the testimony you heard. All that's in front of Plum is whether the zoning administrator erred in finding that this facility in exactly the way it was proposed qualifies for a reasonable accommodation. It's not in front of Plum whether we're going to provide for the elderly or not, our strategy as far as neighborhoods, whether there can be a facility here at all in some other incarnation. All that's in front of you is whether the zoning administrator erred, and there's no evidence that the ZA did err, and in fact, it's not incumbent upon the city based on reasonable accommodation under ADA as well as fair housing to waive a zoning ordinance, especially in circumstances such as this where they could do a smaller facility by right. So we'd ask that you deny the appeal.
Okay, that is the, please, no clapping, please. Do you have a recommendation from the committee? Have a question? Yes. To for whom?
For the applicant. As I'm reading the reports, and it to achieve the purposes of providing housing for residents who obviously need housing, why not just work under the state law that allows for the 6-bed
We wrote in the appeal that it's very clear if he goes with the way it is now, he's going to have to duplicate kitchens, and he's done this, and hallways, which means more staff. There's about a 50% increase in costs, which he has had to give on to the residents that live there. Which
it costs more to just to convert rather than rebuild something
that's
new?
Correct. Well, you have 2 kitchens and you have 2 lobby areas rather than one facility. You have to have more people monitoring what's going on. You have to have separate cooks for each facility. There has to be additional staff. There's going to be more staff that are parking in the area. There's been complaints about parking. The bottom line here is that he is reducing the amount from 12 to 11. They're talking about a 2-story facility. There's only a small section in the back of the building that is a 2nd story. It is a single-story facility, just like the one here. And I brought this today because a reporter yesterday couldn't tell which building it was. She had to call me up to ask me which building was our facility. These facilities are not big institutions. They are small. They blend into the community. It is purposely done that way. We don't want to intrude on a community. But the bottom line here is that my client, when it is 9 or more, he provides for low-income people. I want you to know that. If it's less than 9, then the city is forcing him not to have one space available for a low income. So by preventing him from having this, there will be no low-income people in the facility. On top of that, he had one resident, they claim that he's in this for the money. One resident that just passed away not too long ago, her family ran out of money 3 years ago. They kept her there free of charge for 3 years.
Thank you. And how would you respond to the ZA's determination that the proposed development would intrude or put a more intensive use into an R2 area?
Again, if we were asking for more residents rather than less, they might be able to get away with that argument, but they're allowed under state law to have 12 residents there. We're asking for 11. So we are reducing the amount of residents that are going to be living at the facility. We are also reducing the amount of staff. So the misconception of the surrounding community that this is going to be worse than what he is already entitled to do under state law is not correct. Again, if he follows what the state has allowed him, he doesn't even have to be here today. He can have 2 separate facilities. He won't be able to have low-income people as residents because he can't afford it if it's less than 9. And he, in fact, will have double the amount of staff, which would be a larger intrusion on the surrounding community. This is why we invited them to come and see for themselves, and only 3 people showed up. I'm very disappointed. I would love for these people to come down to one of the facilities. We have invited them. My offer remains open. We don't want to intrude on any community, but everybody who is complaining about this, they all have family members who sometime or another are going to need the services of a facility like this, and this disease is getting worse, not better, and we again have a responsibility to provide for our elderly that are stricken with this disease.
Great. Thank you very much.
Thank you.
Please, ma'am, please, ma'am. All right. Yes.
Just a couple questions. Just one, just a quick question. You alluded to, or leads through inference, that if we didn't support here today, that there would be litigation. And I didn't see your letterhead here. Are you currently a practice licensing?
It will not be me that's following through with the litigation. I'm a land use consultant. I don't practice law.
Okay, I didn't want to have a debate. I just had the question, so I appreciate it. That was the only question I had for you, but I appreciate that. Thank you. I did have some comments, though, however, and I did want to ask our staff a question. First and foremost, after reading all the cases and the documents, listening to staff, looking at the staff report, and listening to the testimony, I'm surprised. I'll just make some observations first before I ask any questions. I'm first surprised that the owner sends a representative and the owner's not here. Let me just put that on record. I'm sorry, I'm not looking for any dialogue, sir. If you want to disrupt the meeting, then we're going to have to ask you to leave. I'm just making my public observations. I listened to you. I listened to all the testimony. I also wanted to make a observation that the folks that did come to testify, for the record, were either in the business of or work directly for the representative or work at one of their facilities. The ones that came in opposition were the local neighbors that live on or around the facility that would either have the benefits or the impact of what's being presented. I just wanted to make those observations. And I wanted to ask staff, it looks here from looking at the mapping and looking at facilities around the neighborhood, first and foremost, to suggest for 1 second that this body would not take into consideration or care about those with Alzheimer's or the disabled, or if we didn't support this for whatever reason, or to suggest we have an issue or don't have any concern with the elderly is absolutely absurd. And in fact, I think it needs to be stated that just to even make that statement is an insult. We hear cases every day and approve these kinds of situations. We're working on very detailed and significant legislation to allow these facilities by right in certain zones, in fact, that we've been working on for years. And so for even to make that statement is just wrong. In looking at this area, and that's not what this is about. It's about a balance. It's about allowing this use and allowing the protection also of single-family zones. That's what this is about. And so in looking at this, it appears, just from my count, that just in less than a quarter of a mile, we've got over 12 facilities. We've got Melrose Gardens, Martell Avenue, Via Stanley, Country Via, Alta Vista, Hancock Park. We've got Fairfax, even more on Fairfax. This one there's another 5 facilities. There's over 12 from my count here locally just in this direct community. Is that correct? Roughly?
I counted 9 within the zip code. I don't know if some of the facilities you've stated are outside of that zip code, so
I'm not sure what the
2 mile
zip code
stretch,
boundary
the
is.
2-block stretch between West Hollywood and Melrose, I counted
2-block
9.
step, you've got 9. I counted 12. And there are other types of facilities, though. There may be rehabilitation facilities, there may be other facilities directly in the single-family zone. So what I'm suggesting is that to deny or not deny or support one single facility when, in fact, there's either 9 or a dozen or somewhere in between or more, just from our counts and observations, is insanely ridiculous. Based on that, I just want to share that this body absolutely supports these facilities in the right place, but there's got to be this balance as well. And so those are my observations, and I appreciate it, and we'll go along with the recommendation, but I wanted to put the facts out there. Thank you, Mr. Chair.
Thank you, Councilor. Please, folks, we're trying to finish this hearing. There's one point I wanted to raise, and I just need clarity. It states that state law allows residential care facilities for the elderly by right in all zones as long as there are 6 or fewer beds. If these facilities meet state regulations, they do not need to obtain any approvals from local agencies. So by right, they have 2 lots, 6 and 6.
Well, in this particular case, it's a duplex, so you're allowed 2 units on the lot, so they can have 6 beds in each unit.
So,
but what happens with these duplex units is they have to have a separate license for each unit. So you'll see in some of the records that it'll be Unit 1, Unit 2, or something like that, and but they must be independent of each other, which is Mr. Chernin pointed out that you have to have 2 kitchens, 2 hallways, things like that.
So the reasonable accommodation is so that they could also have the office area, or is it just everything under that umbrella?
Well, one of the reasons we turned it down as a reasonable accommodation is the most reasonable accommodation cases we've seen are, people asking for wider driveways to accommodate their vans, for handicap vans and the like. This is the first one that I know of where a developer is actually requesting to build a building from the ground up for that particular purpose. It may be allowed under the law, and in fact, we made finding number 1 said, that it is legal under the law, but we're still looking at this as from the number of uses in the area that are already doing this, is that there's a real need for it, or the other finding number 4, which is the one about the zoning. We think this is basically using a reasonable accommodation in order to put a residential care facility which is allowed by right in the R4 zone, into an R2. And that was one of the reasons we denied the case.
And that's where we're hanging our hat, so to speak.
Correct.
Okay. So with that, I would like to entertain a motion.
I'd like to make the motion that we accept the recommendation to deny the case.
Okay.
The appeal, right?
Deny the appeal.
Deny the appeal.
I will second that, and, I believe, as Mr. Englander said, we supported these types of housing projects, but in this case, it just, our standard of review is to see if the zoning administrator erred, and there's nothing that really sticks out. This is a well-reasoned analysis of the reasonable accommodation request, and the main concern I was just mentioned is that, a reasonable accommodation by totally building a whole new structure just doesn't fit into what we believe we've seen in the past or what the intent of reasonable accommodation should be. So it's very hard to fit this into that, and so on that basis I too would second it, although it's a difficult one.
That'll make it unanimous. That'll be the action of this committee. I did want to make sure that item 5, that we'll be continuing that to Plum June 19th and Council July 3rd. That one got away from me. And I should have asked the director to make his report at the beginning, but I apologize. We do have item 1 left, and that's a closed session item. My understanding is we can have public comment at the outset before we go to closed session.
Before you go on, can you just clarify for the public what happened on the previous item so that everyone's clear before?
Okay. Well, what occurred is pretty straightforward. We denied the appeal requested by the applicant regarding the determination for reasonable accommodation, so the appeal has been denied. So that was the action of this committee on item number 3. So before we start public comment, I want to make sure, Mr. LeGrand, you'd like to give us your report?
Yes, I'll give you a brief report. Mike LeGrand, Director of Planning. This past Saturday, we had a very well-attended event. It was a training for our Historic Preservation Overlay Zone board members and interested parties. It was held in Hollywood at the Scientology Celebrity Center hosted us, and it was an excellent opportunity to tour some existing HPOZs. City of Los Angeles now has the most robust historic preservation program and number of overlays. 13 out of the 15 council districts have historic preservation overlay zones, and our staff under the leadership of Ken Bernstein has done an excellent job in expanding that program. We have the second largest number of HPOZ registered units and lots, second after New York City only. So our historic preservation program has really taken off in the past few years, and we're excited to provide that training for neighborhood councils as well as our HPOZ board members. And so we're excited to provide that training, and it was well attended, and just want to report back on that. Thank you.
Thank you. And perhaps at the next meeting we can talk about the impacts from the budget and how we see that influencing the department one way or another, just to get that reality check, and hopefully some of the planning staff is listening to these proceedings so that they're in the loop and we all understand how hard we're trying to support the planning department with the different efforts through the council.
Thank you to all 3 of the members here. You've been very helpful in the budget process, not only in understanding the tie between planning and economic development, but also the policy work that we do to create ordinances and move the city forward to have updated regulations. So I appreciate your leadership, Councilman Reyes, as well as Councilman Huizar and Councilman Englander, the countless hours that the committee spent going through the budget proposals and to actually come out with a solid financial budget, but one that also recognized that some of the cuts that were proposed were too deep to maintain the planning functions at the core level, and the help that you gave us through that process was really appreciated, and we look forward to working with you on the report backs that were requested and coming forward with some solutions to help move us forward and move away from a case-by-case way of planning Los Angeles into a more programmatic, broader look at the city and how we grow.
Thank you, sir. And I also want to thank the City Attorney's Office for all their great work in supporting us in this endeavor. So thank you, City Attorney. That being said, let's move on to item number 1. This will be closed session, but for the record, can we introduce the item? Then we'll open up for public comment.
Sure, council members. Item 1 is a city attorney report. It's relative to a court-issued writ of mandate in the case entitled West Chandler Boulevard Neighborhood Association et al. Versus City of LA.
Okay.
Good afternoon. My name is Tayo Popula, Deputy City Attorney. As stated, my office is going to advise or give a report to council.
He's basically just introducing.
Oh, okay. He's
introducing the case.
Okay, all right.
That's all. It doesn't want to know what we're listening to.
No, we're not.
And I want to make sure that the public knows what they're commenting on.
Yes.
So, just give us a very general introduction.
Yes, that's correct.
So, are you done?
I'm pretty much done, yes.
Because that sounded like they cut you off.
Well, basically, as I was saying that...
Give us the facts and everything but the facts.
Yeah, my office is going to advise your committee or give you a report as to the status of the litigation in closed session.
Okay.
Yes.
Close one. All right. So let's go through public comment cards. We have with us Mitch Rahman. Rich, are you here? Yeah, Mitch, then Noel Weiss, and then Scott Swybeck. And just keep an eye on the clock.
My name is Mitch Raymond. I live at 13123 Chandler Boulevard, about 150 feet west of the Chabad of North Hollywood. I'm from the West Chandler Boulevard Neighborhood Association. We have hundreds of neighbors that are against an oversized project at this location. Some of the neighbors happen to be members of Chabad. One specifically is Jackie Ratner. Here I have a letter written from Jackie Ratner to Councilman Koretz. I'm writing to you to express my deep concern over Chabad of North Hollywood's proposed expansion project. I am the original benefactor who made it possible for Chabad to access this location 28 years ago. In addition to the synagogue, it bears the name of my beloved daughter, Sarah. Having lived in the southwest corner of Ethel and Chandler across the street from Chabad of North Hollywood for over 3 decades, I can attest to the wonderful and unique character of my neighborhood. Chabad has been a part of this neighborhood, and I certainly have no objection to Chabad seeking to modernize and upgrade their facility. However, what Chabad is proposing is simply out of line. This location is not suitable for a full-service synagogue. When we purchased this property and deeded this site to Chabad, the city acknowledged the limitations of this location. While granting permission to Chabad, they did so while keeping the character of the surrounding neighborhood in mind. That is why this is a small, limited-use synagogue, nothing more. If Chabad wants to place a somewhat larger structure on their current site, that seems reasonable to me. But what has been approved is more suited for Burbank Boulevard and not Chandler Boulevard. To permit Chabad the right to damage the fabric of this special neighborhood is just plain wrong. When I first learned of this project, I remained neutral, but having seen what has transpired and having talked to other neighbors, including some members of Chabad, I have come to the conclusion that I can no longer stay silent. While I do not seek to deny Chabad the right to improve their property, I am asking you to maintain the spirit of what was originally granted at this location and prevent a full-service synagogue at 13079 Chandler Boulevard. Here I have the original CUP.
Thank you, sir. Can you just close this?
Which says this project should not be increased in size on the original CUP and must be conducted at all times with the due character of the surrounding district.
Thank you very much, sir. Noel Weiss?
Thank you. Council members, this is basically another variance situation. Basically, the Court of Appeals said, in essence, in fact, rather than me paraphrase it, let me just read it briefly. It says, in essence, the action of the council in approving the conditional use permit as well as the zoning variance, they failed to address the evidence before the zoning administrator. This is City Council under 245 where we didn't go through Plum. It was waived out of Plum. Jack Weiss's last 2 weeks. This is his parting gift to you gentlemen. But basically, the evidence before the zoning administrator was not supported, and nor did the City Council explain how the zoning administrator's decision to limit the proposed building to 6,100 square feet above ground and limit the size of the assembly space to 2,400 square feet, combined assembly versus sanctuary area, was erroneous or an abuse of discretion. So basically what we had again, and I think the points made by Mr. Weezer, the points made by Mr. Englander with regard to the other matters are appropriate here because what we're talking about is following the rules. You have, by definition, the violation of land use conditions is a public nuisance. No different than the public nuisance we talked about with the hotel, no different than the situation that we talked about before. The rules should apply the same for everybody. They didn't apply the same here because Jack Weiss basically rammed this through, and the council in maybe 75 seconds really didn't give it the consideration that it needed to give it. Plus the fact is what we want is a redo. We need to have this go back to the zoning administrator, and what we have as well, by the way, just so that you understand, and maybe 2 quick points. One, Chabad is still working on this. This is reckless. The city attorney has said in open court they have no land use entitlements, they have no building permits, but they're working away because they figure they can basically jam this through with whatever political influence they have vis-a-vis Mr. Koretz's office with votes and money. Secondly, indemnity. There's an indemnity provision in the land use entitlements. I want the city council to start enforcing that indemnity. The city attorney, the planning department spent a lot of time and money defending these land use entitlements. Chabad should have to repay the city pursuant to that indemnity, and we need to do it on all of these types of matters given the planning department's financial needs as well as the city attorney's financial needs. Thank you very much.
Thank you very much. Next speaker is Scott Swaback, and then Tess Jones.
Good afternoon. My name is Scott Swaback. I live at 13115 Margate Street, about 400 feet away from the door of this project. As Mr. Weiss has stated, this project was opposed by our neighborhood. We have an association of about 170 households sued, one on appeal, despite the fact that the entitlements and the permits have been declared invalid by the court, which was acknowledged in open court by the city attorney's office. The construction continues at a furious pace on this project. The Superior Court judge, Judge Chalfant, informed Chabad in open court that their conditions are unenforceable, that they are building at their own risk, and they have been told this not only by Superior Court, but by Appellate Court and by the building department as well, and that there is no reason why this building could not be torn down if so ordered. They are building so that at some point they can say, look, it's already built, don't make us tear it down. We want the building torn down and brought down to a reasonable level that fits in with the current mansionization laws in effect in our R1 neighborhood. The zoning administrator in her original report stated that she couldn't grant anything larger than 10,300 square feet, and anything larger would be a self-imposed hardship. The full South Valley Area Planning Commission rejected the project entirely, stating that the building was too large for the lot, no setbacks, not in keeping with the surrounding neighborhood, and that despite the claims made by Chabad, a larger building would bring a larger congregation, bringing more traffic, more congestion, more pollution, and more noise. It also expressed concern over lots of ambiguities and inconsistencies that existed between the CUP and the various leases and agreements in place. In effect, it said that it was the wrong building for the wrong site. Lastly, I would just ask, would you want this building on the corner of the street on which you live?
Thank you, sir. Tess Jones, then Dee Tangrabbit.
Good afternoon. Entitlements are purely a discretionary act. Elected officials must be as careful and thoughtful as possible in granting such entitlements. That did not happen in our case. The City Council has taken the words of the developer as the truth, and the reality is he's been disingenuous going all the way back to the beginning of this in January of 2008. The congregants do drive. The neighbors know that for a fact, witnessing it every day of the week. Therefore, on-site parking is necessary, the number of spaces as dictated by the square footage of the building. Chabad's representatives have stated on the record that they are not about growth, but that is exactly what this is. Why else would they want a building almost 10 times larger than their previous one? The zoning administrator stated in her original decision when granting a smaller building that the applicant wants a building to serve 35 people on a daily basis. This is clearly not the case. In addition, ambiguities in the CUP must be addressed. The required parking lease, Chabad does not have one. The revocable permit for the use of city-owned land, Chabad does not have one, nor has there been the necessary public hearing on this issue. The land leased from the MTA, it is a month-to-month lease. Temporary conditions tied to a permanent structure defies common sense. Chabad's hodgepodge of a CUP states that activities must take place indoors on all but a few days of the year. Their current plans show a very large rooftop terrace accessed by 2 staircases and an elevator, and plans for basketball courts and a playground. These are only a few examples of the blatant disregard for the rules at the expense of the residents. This project is simply a Trojan horse. Chabad may want an excessively large commercial building in an R1 zoned neighborhood, but these decisions should be about need, as well as the needs of the residents. Thank you.
Thank you, ma'am. Dee Tangravit, and then Ben Nabakun.
Good afternoon, all. My name is Dee Tangravit, and my family have been living in a nice neighborhood. We live across the street from the Kaaba. Now the Kaaba have been building unlawful, gigantic building, which call just like big mountain in our neighborhood. And this will causing a lot of traffic and also parking. They're asking for only 5 parking space for a big gigantic building. As a nice resident in the area, I asking you to stop the unlawful building. Thank you.
Thank you, ma'am. Ben Nabakun.
Yes, good evening. My name is Ben Nobakun. I live in 13109 Chandler Boulevard, next to that Chabad house. The Chandler Boulevard is a beautiful Sherman Oak area, nice neighbor, very good neighbor, a quiet area. And someone tried to build a building, a large building with illegal building in there. Every day I wake up with somebody make so much noise next to my house, hammering the metal, sometimes drop the metal, and make so much noise in there. I talk in my mind, this is an illegal building. How come nobody can stop them? This is the U.S., this is Los Angeles, this is the Sherman Oak area. I powered my citizenship. I came here 30 years ago, and I believe this is a wonderful country what I live in. But today, I have been a nightmare. Would you please stop that? Thank you very much.
Thank you, sir. Michael Carrion, are you here? Okay, that concludes public comment for item number 1, but we do have one person for general comment, and out of courtesy, we'd like to hear from him, Herbert Cortez. Before we close, Herbert Cortez for general comment. This item is not on the agenda. Herbert Cortez?
Yes, Herbert Cortez.
So you're going to speak to us on an item that is not on the agenda.
Yeah, I guess this room is about finding solution, right? And I would like to be direct to the right direction, if you could. What I have is I hear by coincidence, but I would like to expose about the situation that we have in all California, and not only all California, the whole world, about the styrofoam that is creating a lot of problems. We all know all these consequences that we have in that. But I have a solution for this styrofoam to be used, and what I don't have is the facilities or the money to make it happen. And if I'm in the wrong spot, please let me know or direct me to where to go, because
it's not clear to me what it is that you're seeking. What is that you're looking for?
Trying to get the styrofoam, keep it off from the fields of the trash.
I see.
I believe that if we started with I know we all get the styrofoam and somehow into our houses, or the people who have already their business. If we have a fee enforced in those people, we may have this styrofoam keeping off from trash.
Okay. Can I make a suggestion? Can I make a suggestion? Can you write us a letter, send it to my office, and then we can see how we can respond to you in a manner that's more specific and clear? I understand what you're saying. It sounds like a policy issue. Unless, Roberto, you have any other ideas?
It sounds like an EQ matter. Maybe he can also refer it to the EQ committee.
Environmental quality, that's right. Environmental Quality Committee could also listen to your idea. I'll be more than happy for you to send us a letter that we can direct you and be a little bit more direct as to what your options could be.
Do you have a...
We'll get you a business card. Susan, can you get him a business card? Okay.
Thank you very much.
Okay. Susan Wong will see you right now. We'll get your card. Sir?
Very quickly, Mr. Reyes. Since Mr. Weezar's here, out of respect to Mr. Weezar and his desire to have a little bit more affordable housing, he did have one of the motions for SB 1818 that is pending before your committee was Mr. Weezar's motion, and I would again respectfully request at least a discussion about the implementation ordinance, the SB 1818, because I think it will...
Thank you, Mr. Weiss.
Well, can I just finish my sentence?
Finish your sentence, but you didn't fill out a card, but go ahead.
Okay. I'll fill out a card.
Okay.
But because, Mr. Weezar is hopefully going to be in a position here to be able to tell his constituents that, you know what, we did deliver a debate and a discussion. And I think that's all the public really wants, a debate and a discussion on what the affordable housing policy is of the city. And this SB 1818 implementation legislation that you are bottling up in this committee is denying the public the benefit of that discussion. And it's really, really important because for the planning department to do its job, to maintain its integrity and independence, we need a debate, we need a discussion, we need a resolution. Mr. Weezar put in the motion. I know he was sincere in doing it, and I would just ask you to respectfully schedule it for some consideration. Thank you.
Thank you, Mr. Weiss. Okay, so let's close down the room so we can start on the closed session. And that concludes general public comment. I'll be good to go. City Attorney, item number 1.
All right, Deputy City Attorney Ken Fong, I just want to report that no action was taken on item number 1 dealing with the West Chandler case.
Okay. As far as closing this, that's all we need to say? We can
that's it. You've already had public comment, so you can just close the hearing now.
Okay, so we'll close the hearing on item number 1. No action was taken. And general comments have already been taken, so that essentially concludes this meeting. Thank you very much.
It goes to the council, and there'll be a report, no action report to the council. But the council is what they do in council.
Okay.